Very warm good morning. Myself Abhishek Bhaskaran from the Department of Mechanical Engineering. First of all, I welcome all the participants who all are present here. I hope all are safe, and I like to welcome the resource person and faculty members of various institutions. A very warm welcome. E-certificate will be provided after filling the feedback form from which it is description box. Now I invite Mr. David Tyling, Assistant Professor of Department of Science and Humanities, to give the grand introduction about Francis Xavier Engineering College.
Francis Xavier Engineering College, Vannarpete, Tirunelveli, is one of the best autonomous NBA accredited institutions in Tamil Nadu. The college is awarded with gold category by AICTE CII survey for 2 consecutive years. FX provides holistic education and enhanced skill training to make its students industry ready. Unbeatable placement record, cutting-edge research, state-of-the-art applied labs are the hallmark of FX Easy. Get enrolled and experience unlimited learning.
Thank you so much, sir. Now I like to invite Dr. Joe Patrick, Professor, Department of Mechanical Engineering, Francis Xavier Engineering College, to address about the Patent Information Center of Francis Xavier Engineering College.
Good morning, everyone. It gives me an immense pleasure in inviting all for this online workshop on IPR. I am privileged to share a few words about the progress in setting up the Patent Information Center on campus. We have been granted a fund by the TNSEST to establish a Patent Information Center in FX Engineering College. It is indeed an accomplishment like adding a gem in the crown, as we are one among the only 2 patent information center in the southern district of Tamil Nadu. Other one is at MS University Tirunelveli. Let me take this opportunity to thank everyone who has been a part of the progress in setting up this cell. I would like to place my sincere regards to Dr. Chandrasekhar, who was instrumental in bringing it on campus. I would also like to place on record the contribution of the heads of various departments for their support. Our faculty members are very exacting and in applying and getting patent for their invention. So far 35 inventions are published and examiner report is received for 5 inventions. Many awareness program and workshop has been conducted in the recent past which has been received in positive feedback. I would request the heads and all the faculty members to make use of the center to the maximum. Thank you. Thank you again.
Thank you so much, sir. Now I invite Dr. Muthukumaran, Professor, Department of ECE, Francis Xavier Engineering College, to introduce the resource person.
Good morning to Nandal Haider here. It's my privilege to introduce our resource person, Parvez Kutrali, to our online workshop. He is going to talk about patent commercialization method and strategy. Professor Parvez is working principal associate in Kurana, and additionally he focused on the working business development and client relationship relating to the IPR strategy, patents, trademarks and copyrights. In earlier, Parvez is a software inventor, patentee and entrepreneur and has obtained patents for his invention in India and USA. He has experience of developing and inventing a software, drafting patents, patent searching, conducting patent workshop, commercializing patent rights, and managing a software IPR related to startup company. He is also a registered patent agent admitted to practice before the Indian Patent Office. Parvez has actively organized and presented several seminars in university, academic research organization, and various industry forums such as MSME Development Institute, Mumbai, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, Sardar Patel Institute of Technology, Mumbai, GH Raisini College of Engineering, Nagpur, Institute of Chemical Technology, Mumbai, Manipal Institute of Technology, Manipal, and World Trade Center, etc. etc. As a part of creating the awareness and various aspects of intellectual property rights and promoting the innovation and creating the effective intellectual property system. We feel so honored and lucky to have as a speaker today. So now I hand over the session to our speaker, Professor Parvez. Thank you so much, sir. Thank you.
Thank you so much for your introduction, sir. Participants are requested to raise their queries in comment section. It will be cleared at end of a session. Now I handle the webinar to resource person Mr. Praveed Kudorli, Principal Associate, Karuna and Karuna Advocates and IP Attorneys, IIPRD India. Over to you, sir.
Okay, shall I begin? Okay, right. Uh, okay, let's welcome to the session on patent commercialization. Let's begin. Okay, so when we are talking about patent commercialization, the first thing that we look at is what is patent commercialization? Because a lot of people work on patents, they create patents, they create inventions, then they file patents, and then they talk about commercialization. Okay, so how we'll go in this session today is get an initial introduction to patent commercialization, valuation of patents, etc., and then we'll look at some examples and case studies to really get a real life practical understanding of what commercialization means and what it involves, what are the various types of parties and issues that can come when it comes to commercialization. So that's what we'll be looking at in the session today. And at the end of the session, in case you have any queries, you can ask that if that is permitted, or you can type in your questions into the chat box, or you could even send questions later on also after the session is over. Okay, so that's how the whole session is structured for today. So, first question, what is patent commercialization? So, there can be various ways in which a patent can be commercialized. And the reason why a patent exists primarily has to be that it has to be commercialized. The reason why people, after they come up with some new technology or some new invention, they are not required to file a patent. They may create a new technology, they may start using it, and they can give it to others for using that technology. Why do people file for a patent after they create a new technology? Because they want to get an exclusive right on that invention or technology, such that other people cannot use that technology, that idea, that new product idea, or that new process idea without their permission. Okay, otherwise, if you don't want to stop others, if you want everybody to freely copy and use your invention, you shouldn't go and file a patent. The reason why you file a patent is because you want to get the right, we called a patent right, and using that patent right, you want to stop others from copying, using, misusing your invention idea, your new product or process idea without your permission. And why do you want to stop others from using it? So that you can decide who gets to use it, and on what basis will you decide that this person can use and this company can't use. In Because you will decide on the basis of what am I getting in return. Am I getting something in return? Am I getting some money or some other commercial benefit or some commercial advantage, something in return? based on which I'll give the other person a right to use this technology and maybe make and sell products or provide services based on that technology. So that is what we are talking about, is commercialization. People who create the invention, who spend the time, effort, and money creating the invention, and then getting it patented, and then maybe manufacturing and selling and distribution also cost time, effort, and money. They want to get something in return, and that's the whole idea of commercialization. So, what is patent commercialization? There are various ways in which you can commercialize, especially a patent. One is, if you are a company, maybe medium sized or a large sized company, maybe the main factor driving your innovation or invention creation was that you want to use it yourself in your own company's products. Now, this could be you are a well established company, you have a certain line of products, you have come up with a improved part in one of your products. For example, you are a washing machine manufacturing company, you have come up with an improved motor which consumes less power. Okay, so that's a new technology, you've created it and you have patented it. Now, what you would do is, when you are making and selling your washing machines from now onwards, you will incorporate this improved technology, this improved motor which consumes less power. Therefore, your products are better than other washing machines from your competitors in the market. Your washing machine motor consumes less power, your washing machine consumes less power. It has that advantage over your competitors' washing machines. So that is the benefit that you get by having a patent. And you will not give the right to your competitors to make use of your technology because you have a patent right or you applied for a patent right. And you will tell your competitors, even if they approach you, okay, you've got this nice improved motor. We also want to use this improved motor in our washing machines. Will you let us use this idea? You might tell them, no, I want to have the exclusive right. I don't want to give you the right to have an improved washing machine with this motor. Therefore, I will not give you the right. We will use this technology in house ourselves in our own products, and we'll sell those better products in the market, and we can charge our customers more, and we are providing them better value in terms of the product. And that's how we derive some commercial benefit or advantage out of our patent. So this is one way you commercialize an invention. Another way is, you will license your invention to other parties. Okay, what is the meaning of a license? For example, if you own a property like a house, now a patent is also an intellectual property. Even though it's intangible, it's an idea which you have sort of protected, and it's become a property because you've got a patent certificate. It's an intangible property, but the idea itself, the patented idea or the technology, can be licensed to other parties to use. For example, if you are maybe not a big company, a big organization, maybe you're one person inventor who has a technical skill in terms of creating good inventions or innovative inventions, but you don't have the money, the resources, the contacts, to actually make and sell the product, which will require maybe hundreds of crores of investment in setting up a factory, employing people, distribution, marketing. Cost will run into crores or hundreds of crores of rupees. You are an inventor, you have a good strong technical mind, you can come up with good ideas for improving technical products, but you don't have all this money and resources to make and sell it. In such a scenario, what would you do? One of the ways of getting some commercial advantage, commercializing your technology or your patent, is to license this technology to various companies or other parties. Okay, for example, if you are the inventor who has created this improved motor for a washing machine, you will approach washing machine companies and ask them, okay, I have come up with this improved technology, do you want to incorporate this technology into your washing machines and sell it in the market? And your washing machines will be different, better than other washing machines. They'll consume less power, your customers will definitely want to have that, you can charge them more money for that. And in return for the right to use my technology, you can pay me this much licensing fee. This is something that has to be discussed, negotiated, agreed, and written down in an agreement and signed. This kind of deal is what you would look to get done with potential users. Okay, so this is one example of how you may commercialize your patented or patent pending technology. You license that technology to other parties, either because you can't make it, yourself, or you are making and selling it, but you are a very small company, you're selling only hundreds of pieces of that product, but this product actually can be sold in the thousands or tens of thousands in the market and maybe your reach is restricted only to, say for example, Tamil Nadu. You can make and sell and satisfy the demand only in Tamil Nadu, but what about the rest of India? Don't you want your invention to be used in the rest of the country also? So in that case, what you'll do, you will license it to different companies which have the geographical reach in northern India, western India, eastern India, central India, etc. Okay, subject to whatever licensing agreement you sign. So that's how you may make either not make and sell that invention yourself, or you may make and sell it on a limited scale. But to make sure that your invention feature, that new technology that you have created reaches a wider audience, you may want to license to other companies which make and sell such products, and therefore you will collect license fee. That's the commercial benefit or advantage that you get from a licensing deal. Apart from as looking at the example of the house, when you own a property like a house, now intellectual property, patent is also a property even though intangible. In case of a physical property like a house, when you own a house, you can very well rent out the house to somebody else. Okay, which means that you remain the owner of the house, but you rent it out to somebody else. Maybe they can stay there for 2 years, as long as every month or every 3 months they pay you a certain rent amount, and at the end of 2 years they are supposed to move out from there, and you will again have possession of your house, and all along the ownership of the house remained with you. Licensing is similar to this kind of a property arrangement or agreement. Okay, when you license a patent, the ownership of the patent stays with you, but you are letting other people use your property, okay, under certain terms and conditions, and subject to a certain rent or a license fee. Now, when we talk about the third aspect on the screen that you see right now, sale of the patent application, it's like when you sell the patent application, you're completely selling off and giving away this intellectual property called your patent. Okay, that patent ownership itself is getting transferred from you to the other party. After that, you have no right on that patent or that invention. Okay, it's completely transferred to the other party, and you might get some lump sum amount or some permanent advantage or benefit or something in exchange or return, and in return for getting that money or that benefit, you are completely giving away, transferring the right to the other party who has bought that patent or that patent application from you. Okay, this is like when you sell off your house, you're selling the house, ownership of your house is getting transferred to the other party. After that, once the agreement is signed, the money is paid, the deal is completed, you will not even be allowed to go into that house without the permission of the new owner. You are no longer the owner, you no longer have any right on the house. Same thing with the patent or patent application. You would not be allowed to use that invention unless that new buyer of that patent, new owner of the patent, gives you the right to use it. Okay, it's a complete transfer of ownership, and once that other party buys it, they can either make and use it in their own products and sell it, or they can license it, or they can take some commercial advantage out of that patent the way they want. It's up to them. You have no say in the matter once you have sold off your patent or your patent application. Okay, the other way, one of the other ways of getting commercial advantage or commercializing your patent is by cross licensing. Okay, imagine you are a fairly large size, medium size, or a large size company which has patents on some of your technologies, and which you are either using yourself or you're licensing only to a select few companies whom you are clear are not your serious competitors. You don't have a problem with they using your technology, but your main competitors, you would normally not license that technology. You don't want your competitors to have the benefit of your patented technology. You want to have that monopoly right yourself, so normally you wouldn't license that to them. Okay, but there can be scenarios where even though you don't want to have your competitors having access to some of your innovative important technologies, some situations you may consider licensing your valuable technologies and patents to your competitors also, right? What kind of scenario will that be? Imagine you have certain valuable patented technologies inventions which you own the right to, and you are taking advantage, you're selling products like that. Okay. On the other hand, your competitor also wants to use the technology that you have created. They see it's very useful, there's a lot of demand, a lot of people want to buy products with that feature. So the firstly, the your competitor is interested in getting that or licensing that technology from you. Second important factor has to be there for you to be willing to license your technology to the other party, which is not pure financial, direct financial consideration, but something like your competitor, that company itself is an innovative company. They themselves have created new inventions, and they themselves have filed patent applications and obtained patents on some improved technology, some innovations, some good features which you want to put in your products also, right? So here we have a scenario. You have invented some technologies, patented them, and that is giving you an advantage when you incorporate those features and sell in the market. Your competitor similarly has invented some new technologies, improved technologies. They have patented them and they are using it in their products, and they are getting the benefits of that. Their customers are very happy with them to get those benefits. Now, both of you want each other's technologies also. Apart from your own technology which you are already incorporated into your products and selling, you want to also incorporate the other parties, the competitors innovative technologies in your products. Okay. So in a situation like this, you can sit down with your competitor, discuss, negotiate, and work out how you may license some of your patented technologies to your competitor, and your competitor in return will license some of their patented innovative technologies to you for use in your product. Okay. So between the two of you, you get access to each other's technology, not just your technology but the other person's technology, which can turn out to be a very good win-win situation for both sides, and the your customers as well as your competitors customers. Now you'll wonder, really, can this happen? Why will competitors do this? Sometimes these two competitors may get together, they may improve each other's products by incorporating each other's technologies, and they together, having this, can actually keep out some other third, fourth, and fifth, sixth competitors. They might even have an understanding between themselves. We'll license only between the two of us. Others will do not license it to, because we are the most innovative companies and we have got this. And once we incorporate each other's technologies, our products clearly are much ahead of the third, fourth, fifth, sixth, seventh, eighth, all the other competitors. So the two of us, if we work together and cross license and use our technologies, we'll have an advantage, the two of us, over all our other competitors. So in a way, two competitors are sort of becoming partners to keep out the other competitors. This is another way that you can do commercialization of your patented technology by cross licensing. And the last thing that we see on the screen is enforcement of patents. Now, what do I mean by enforcement of patents? Imagine that you are an inventor who has created an invention. It is useful, it can be used in some products or systems, it has value, etc. But actually you don't have a factory or the setup or resources to make and sell it yourself. Okay. So you can't use it yourself, in-house is not there. Okay. You have been trying to license the technology or sell off the patent. Okay. But nobody has shown interest in doing that. They see you're just a small entity. The big companies who actually should have licensed from you or bought your technology feel, okay, this is a small inventor, some invention. If we don't buy and commercialize it, maybe this person will not be able to sell to anybody. He's just a small inventor located in one place somewhere. He doesn't have access to a lot of companies or resources, can't market, can't promote his patents, and probably won't not be able to license it. So we need not take license from them. We need not buy it. Generally, big companies are not interested in taking other people's or small inventors' technology and licensing them. This is the sad part about what you learn about commercialization. Especially, you will see this when we come to the case studies and examples a little later in this session. Okay, you'll see how big companies behave when there is a small inventor who has created some innovative technology and patented it also. You will see what the big companies do in terms of licensing or buying that technology. Okay. So even that is not happening. So first type of commercialization not happening. I'm not using the invention myself. I've offered for license and sale, but nobody has taken a license from me. Nobody has bought the patent or patent application from me. Cross licensing I can't do because I can't take somebody else's technology and use it. Firstly, I'm not able to use my own patented technology because I don't have the factory resources, money, nothing I have. So I can't use my own technology. What will I do cross licensing somebody else's technology? That option is not there. So the first four ways of commercialization are not open to me. I'm not able to do that. It's not worked out. I have invented a technology, spent time, effort, money inventing the technology. I've filed for and obtained a patent right on that. I've got this intellectual property called a patent right, patent certificate, but nobody's interested. Okay. But it so happens that my technology is so useful. Some of the companies out there, medium or big size companies out there, are actually using that technology without having licensed it from me or having bought the patent from me. They are using it because they find it so useful and they feel, okay, this is just a small inventor. What will he do? Suppose I use it, what will he go to court? Okay, we have a lot of money and big time, big shot lawyers to fight the case in court for months and years, and this person won't be able to pay the lawyer's fees, so he may not even initiate legal action. Or even if he files a case, he'll have to abandon the case very soon because he'll not be able to afford fighting a case in court, which can itself cost a lot of money and take several years before some or the other decision may or may not come, right? So that's what some people might think. They may start using it without taking a license or without buying the technology from me. In such a scenario, what can we do? When I see, or somebody who might be these kind of firms which help inventors, see, sell or commercialize, or see if somebody is infringing your patent and try to help them, take action against them because they are in this line of business and they can help such inventors. So when I or somebody helping me sees that there are these big companies, medium or big size companies, which are using these technologies and they have not obtained any license from me, then either me with or somebody else, or with the help of somebody who knows how to do this and who might be a firm of lawyers, who are into this line of business, we may file a case against those companies saying we have created this invention, we have obtained a patent, it's been offered for sale and licensing. This company has not licensed this technology from me, they have directly started using this technology. Okay. And without licensing, without getting my permission, they've already incorporated this technology into the product and it's selling in the market. Okay. So now when I file a case like this against that company which is using my technology without my permission, means they are infringing my patent, what situation are they looking at? One is they have to see, okay, whether this person will be able to sustain the case, fight it, spend the money, fight the case for years, etc. Okay, so they must see that I would have some backing from somebody who can support with the case, without charging too much money, or doing it on a percentage sharing basis or whatever revenue is generated. So they may look at that. When they see these people can afford to pursue the case, then they'll think, are we really using the technology which they have patented? Okay, right? And if they see they are, then they are in a dilemma, because if the case proceeds, then a judgment might come in the favor of the inventor saying these people are infringing their patent, they have deliberately done it, they have wrongfully done it, they have in fact stolen the technology and they have already launched products. The court might order those infringing companies, firstly, that all your activities related to this stolen technology you have to stop right now. All products that you have launched in the market or in your go down, you have to withdraw that. And in the process, the company will have to tell its customers, you know what, these products we sold you, we had incorporated some stolen technologies, some patented technology which we were infringing. Those patents we incorporated without getting a proper authorization and license from the patentee, and we had sold such, now we need to withdraw it. Imagine the disruption this causes to that infringer, that company which is using this technology in an unauthorized manner, because the court, the judge is giving an order, a decision that firstly stop all this activity, withdraw all those products, and give an account of the damages of the sales that you have done. And based on that, the case will go on. Firstly, all their activities will be immediately stopped with an injunction. And secondly, the case will go on where I'll fight a case saying that, you know what, without my permission, they have been doing this. They have had a bad intention, malafide intention, and they have, by selling this much, they have caused so much damage to me by not paying it me license fee, and they have benefited, made some revenues and profits out of it, and they have damaged my interest in the whole process. I want damages covering that, as well as punitive damage, means punishment, extra damage, double damages, because they did it wrongfully in an unauthorized manner, right? So the company which is using these technology without my permission, when I manage somehow to start an enforcement proceeding, they will face a situation like this. So at that time, maybe if we say, okay, okay, let's work out a deal, let's settle this out of court. Who wants to go to court for years and spend, lakhs and lakhs of rupees, fighting the case in court? So much time will be wasted. So why don't we discuss and work out some agreement? So in such a scenario, very well, that company at that point of time, because now they are in trouble, they are infringing a patent, they know they have a fairly good chance they'll lose the case, and then they'll be faced with very serious consequences. Instead of getting into that possible risky bad situation, they say, let's settle this out, let's work out in between some deal, some agreement, we'll work out some value, and we'll settle the matter. So in this kind of a scenario, enforcement scenario, they might come and we might discuss and work out, okay, you pay me some so much amount of fixed amount as a license fee for using this permanently, or you pay me this much of a license per year, or based on your per year revenue or profits, you pay me this kind of an amount. Such an agreement will be worked out, such a deal will be worked out and signed, and based on that, I would be getting some money as the inventor and patentee. I would get some money. So that is another way of commercializing your patent, by actually enforcing your patent. Okay. People who are not already using your invention, they don't want to license, they don't want to buy your technology. Sometimes they are using, but they think this is a small inventor, they'll still not license or buy the technology. So we have to, sometimes the inventors or patentees have to resort to enforcement of patents, where they see people who have not licensed the technology are using it without my permission, they are misusing, they are infringing my patent, and then I take action to get this kind of a done, this kind of a thing done, and hopefully work out a settlement and get some reasonable amount of money paid to me. Okay, this is how one does commercialization. So I'm not saying these are the only 5 ways in which you can commercialize. There could be other ways, there could be combinations of these ways of commercializing. Okay, but this is how basically you would try to make money. These are the ways possibly you can make money out of your patent. This is how you can commercialize your patent. These are the strategies, methods, and approaches that you can follow if you want to commercialize your patent. Okay, now let's go to the next slide and look at what is there on this side. Now, this slide here, what we are talking about is valuation of patents. Okay. Now, you might ask, why are we talking about valuation of patents? We were talking about commercializing patents. Now we are coming to valuation of patent. Why is valuation of patent important? Right? Now, when you are saying that I have some intellectual property, I have some asset, and I want to sell or license it. Okay. When you are selling it, or you're licensing and charging a license fee, what is the value you attach to your property, to your asset, based on which you will collect either the license fee or the lump sum amount when you're selling the thing, right? So can you see, valuing your patent is a very important concern here, right? Without valuing, what value will you tell the other party for them to license it or to buy it? So a commercial transaction can't happen unless you first decide what is the value. Only after you decide the value, there can be commercialization. Get this? That's why valuation is so important. Okay, but let's look at this particular slide and understand the traditional, most commonly used methods for valuing patents. Okay, and you will realize by the end of this slide, this is a very difficult thing to do, to really value a patent, to really find the real value of a patent. Very difficult thing to do. Okay, and not just the value is required when you're trying to do some commercial transactions or deals with people, even for other purposes. For example, for taxation purposes, you may need to value your patent or IP assets, applications, or granted patents. Okay, when there is some a merger and acquisition kind of scenario happening, you may want to do a due, as part of the due diligence, you may want to actually give a valuation to your portfolio of IP rights, intellectual property rights, including patents. You want to give some value to that, because when you're doing these kind of deals or transactions, you need to put a certain amount figure, value figure, such that based on that it will be transferred or assigned or valued for the purposes of that merger or acquisition or transfer or hiving of a division or hiving of one division as a separate company. Various activities that you might do, you need valuation. So that's why it's important to get a valuation of your patents, especially. Okay. And when it comes to patents, please remember, unlike physical property, a land or a house or a car, these things, have a very standard value. A house having this much size, made of, this material, this it was made 20 years back, having so many rooms, this much, this would be the value or cost approximately of that property in this area of this city. You can work out, because generally lot of similar transactions are happening in that area for similar properties. You know what it is. For a car, when you're buying a new car, you know exactly what is the value for which you can buy it. Okay. And if you bought it once, it starts depreciating. After 1 year, if you try to sell the car, you can arrive, there are standard values given. Okay, after 1 year, generally, 40 or 50% of the value of the car has already depreciated. You will not get 100% of what you paid 1 year back to buy the new car. You'll probably get only 50 or 60% of that. So it's not so difficult to value such physical property. Okay. But when it comes to intellectual property and patents, valuation is very difficult. Let's look at some of the methods that are used to do valuation of patents. Okay. One method is the income method of valuing patents or intellectual property, right? Patent valuation is based on future projected cash flows or cost savings related to the patent. Okay. Now, what does this mean? Somebody who owns the patent, or somebody who is evaluating the patent, who wants to buy the patent or license the patent, or has some or the other interest in the patent, would do undertake an exercise to value the patent based on the income method. And what they would do is they will try to predict what future incomes or cash flows or license fees are likely to come from this, or what cost savings is, suppose we are using this technology in house, our company is using this technology in house, what cost saving can we have related to this product, or what benefit will this product offer, because of which the customers will pay us a little more money on this. Okay. Or how much increased business do we get, based on which these kind of money flows or cash flows we can expect in our company. So here somebody sits down to project future cash flows. Okay. And once they get the cash flow like this, in 1 year's time we'll make so much money, in the year after that we are projecting that we'll make so much money, then every year this is how, and you make a projection for the term of the patent. Suppose 15 years of the term of the patent is left, you'll predict for each of the 15 years what are the amounts going to be, we are projecting, we are expecting. Okay. Once you work out that every year from now till the next 15 years, every year this is the amount coming. Okay. Then accountants know, okay, if there is a amount coming in the future, the present value of that amount coming in the future is less than what is that amount coming in the future, because of you have to discount, for inflation, opportunity cost, and there are so many factors. Uncertainty, you don't know whether that amount will really come or no, you're estimating, you're guessing, maybe it may not come. So all these factors have to be discounted. So if suppose somebody projects that after 5 years I'm going to receive 100 rupees, what is the present value of that 100 rupees? Maybe it's going to be something like 50 rupees. Okay. Present value of future expected 100, because you have to factor in the interest, you have to factor in the fact that opportunity cost loss, you have to factor in the fact that you may not get that 100 at all, right? So present value of something like an amount of 100 rupees might be 50 or 40 or 60 or 70, I don't know. The accountants know how to do this present value calculation of future cash flows. So two things have to happen. Firstly, somebody has to project that this is the cash flow that will actually arise from now into the next several years relating to this patent. They have to give these amounts. Then the accountants will take over and say, if every year this amount is coming for the next 10 years or 15 years or 17 years, what is the present total value of these cash flows? Okay. And then they'll come out with some number, and that will be the value of the patent when you use the income method to value the patent. Okay. When you use the income method to value the patent. Correct? Right? Now, can you see the problem with this income method of valuing a patent? The future cash flows that you are projecting, they are just projections, they are not the truth. You are not assured that you will get these cash flows in future. You may get, you may not get. You may get less than what you are projecting, or you may get more than you are projecting. You might have thought that you'll get for 5 years, you actually get for 10 years. Or you might have thought that you will get the money for 15 years, but you actually get only for 5 years. So there's a lot of uncertainty. This projection of cash flow is a very difficult thing to do. It's an uncertain thing. In fact, nobody can be sure as to whether these projections of so much cash flows coming are correct or not. They may be totally off the mark, which you'll realize after 15 years. When you see after 15 years, every year, what was projected, okay, this will be the cash flow, and what actual cash flow came, because the uncertainty of life, of business, of the world in general, which is actually these days highlighted by the coronavirus pandemic. So many people had never factored in that our business, our lives, our personal lives, our families, friends will get so affected by this unknown thing, unexpected thing, which happens once in a century, right? And it has caused so much damage, so much loss, so much suffering to people, and loss of cash flows also. Can you see uncertainty in the world and in the world of business, right? You can't say. So when the basic cash flow projections are merely projections, guesstimates, very rough estimate, can you imagine how reliable the income value will be based on the income method of determining? It will be totally unreliable. It's just a method of doing a calculation and getting a number for your accounting purposes. Beyond that, it has no value. Okay, understand this. And I've explained the reason why it is not a very reliable valuation. Second method people use are what is called market method. Patent valuation is based on observations of actual third party transactions of comparable patent to determine a market price. Okay, so market price method, in that you will look at for similar kind of patents and technologies recently, what are the deals that have been done and what are the values that have been obtained, either as license fees or as sale value, sale proceeds. Okay, and based on that you'll sort of assign a value. Approximately patents of this type for these kind of technologies usually get this kind of valuation. So the valuation of this technology will be approximately this much. So this is how you arrive at a value. Now again, what is the problem with this kind of a market valuation? Firstly, when you talk about an invention and a patent, by definition an invention is something new, innovative, and different from all other inventions and all other technologies. Okay, so this concept that we'll value it similar to the closest technologies or similar technologies is itself flawed, because the point of my invention and patent is I'm different from them, I'm not the same as them, right? For example, if you are talking about selling flats in a building, if you have 4 flats on the 15th floor of a tower in a city, okay, and one of the 4 flats has sold for 1 crore rupees 1 month back, then you can say with reasonable certainty that the value of the 3 other flats on the same floor is 1 crore. You'll be very accurate within 2 3 or 5% of margin of error, because it's exactly the same thing, very comparable, same size, everything, same location, same building, same floor. One flat sold really for 1 crore, this also has value of 1 crore, that. Okay, but when it comes to a patent and an invention and a technology, no two inventions, no two technologies, no two patents are similar and comparable. They are, by definition, they are different. Otherwise you would not call it an invention and you would not get a patent on that. So you can't compare it with similar so-called technologies. That is one flaw in this method. Okay, second thing is, currently some similar technologies have sold for a certain value. Okay, but then if it so happens after 6 months and or 1 year, some alternative technologies come for that kind of problem, and these technologies which 1 year back somebody else sold similar technologies for this purpose, now the whole technology domain has moved from these kind of solutions to a different category of solutions, right? So what 6 months back or 1 year back had a lot of value, suddenly similar technologies today may have zero value. Okay, for example, 2G technologies today have zero value. 10 years back they would have had high value, but today the technology has moved on to not just 3G, it's gone to 4G currently and going on to 5G now, right? So just because some time back somebody had sold similar technology for this, the environment, the business scenario, the technology scenario may change, and that kind of value may not be valid. So can you see there are serious flaws with the market method of valuing a patent also, right? Let's come to the third method. Third method is the cost method of valuing a patent or a technology. This approach indicates that the patent's value is the replacement cost, which is the amount that it would cost to replace the item. Okay. Suppose today somebody were to again create that invention and that technology, okay, sort of a replacement of the technology that you've already created. So suppose somebody were to do that today, what amount will it cost? So that is the cost method of determining or estimating what is the value of the patent. Firstly, now what, on what basis will you estimate that this is how much it will cost? Things, the cost, salaries you pay, the resources you, that cost itself keeps on changing. So even the amount that you will estimate will be a very rough estimate. Okay. But the other base, and you're not even looking at what it cost last time for this guy to make. This guy it cost X amount, but he had some free resources which he's not factoring in the cost of that thing. Like like some factory or something which his father owns, he had made use of that, so he didn't pay money, so he didn't factor that cost in. So people don't go by what the inventor spent to get that invention and the patent. They look at if somebody wants to get the invention and patent today, after 3 years, what will be the cost, and that is determined to be the cost of this particular technology or the patent. But the problem, one thing is the calculation of the value as to what really it is going to cost if somebody does it. You really don't know, even that number is not accurate. Okay. Secondly, just because something is costing you 100 rupees to make, can you assume that the value of that is 100 rupees? Okay. You might take, to make a new product, for example, you might spend 100 rupees, but when you try to sell in the market, you will realize, or you may realize, that I can't get even 40 rupees if I sell this product in the market. It has cost me 100 rupees per piece in the market. When I try to sell per piece, I'm not getting more than 40 rupees. So the cost of that's required to make that product is not a good indicator of what value it has in the market. The value can be totally unrelated to the cost. The example I gave you, it costs you 100 rupees to make the product. In the market, you see, I can only get 40 rupees for this product. Or if you are very fortunate, you'll see that it costs me 100 rupees to make this product, but in the market, I can sell, due to various factors, I can sell it for 300 rupees. In fact, I'll make 200 rupees profit on this product per piece. It cost me 100 rupees, but I can sell in the market. The value of this thing in the market is 300 rupees. Great for me, right? But can you see here that this cost method is totally off the mark? It will lead to major distortions and wrong information in terms of using the cost of making that thing for valuing the patent. Okay, the cost may be 100, the value of the patent could be 40, it could be 30, it could be 80, it could be 200, it could be 300 or 600 also. Value can be, actual market value can be anything. You can actually sell it for 40, you can actually sell it for 200, 300, it could be anything. This selling price has no connection with what it is costing you. So can you see, cost method again is inappropriate for valuing, getting the value of a patent. Completely off the mark, right? Now on this screen, looking at these three methodologies, do you get a sense of all these methodologies, which are the best methods people have? These are the methods people use for various purposes to get some number value, some amount, monetary value on a patent asset, patent intellectual property. All these methods have major flaws and limitations, and I can guarantee you, I challenge you, that anytime anybody uses any of these three methodologies, or maybe an average value of these three methodologies, or a weighted average value of these three methodologies to come at some final value of the patent, that value will not be correct. It's most likely going to be off the mark, and usually it will be very wide of the mark as to what is the real value of the patent. Okay, do you get this? The real value of the patent, none of these three methods can actually get. You can just do this exercise, make some assumption about the cash flows, or you can make some assumption that similar technologies have sold like this, so I'm assuming this will also get this thing, and the market and business and technology environment will remain the same, and I'll get the similar kind of value, and what it is costing me to produce is what I'll be able to sell it at. You're assuming that there's some connection between the cost of making something and the amount of value that somebody in the market out there is willing to pay you to get that thing. That's a false assumption you're based. All these methodologies are based on assumptions which are highly questionable. Therefore the values that come out of it will not be the actual real value of the patent. The real value of the patent is very difficult to determine. And do you know when you can know the actual real value of a patent or a patent application or a technology? When can you know that, or how can you know that? The real actual value of a patent you can know only the day you actually find a buyer for that technology. You discuss, negotiate, come to an agreement, sign an agreement, you transfer your patent right to that other party, okay, and they give you the money, you have the money in your bank. Then that amount you get in your bank, you can say, is the real, true, actual value of the patent. Other than that, there is no other way. When you actually do a deal, only then you will know. Or if you are licensing the technology, okay, you get license reviews every 6 months or a year from one company or multiple companies or parties you get. So the actual value you will actually see, you will understand once after the term of the patent is over in 15, 17 or 20 years time. Okay, and then you will calculate every year factually in my bank account how much money license fee came. You total that up, and then you will know what is the real value of the patent. When the actual money comes into your hand, then you can know. Otherwise you can make a claim, my patent value is $1 million. You can make a claim, anybody can make a claim, right? My patent value is $1 million. Anybody gives me 1 million, I'll sell it. Okay, that's why my value is $1 million. Okay, now nobody buys that thing for $1 million for 20 years. By then patent has expired. Okay, so do you think the value of the patent was ever $1 million? No, never. Now you know exactly what is the value of that patent. The value of that patent is zero, and that inventor and patentee spent $100,000 inventing, creating the invention, working on it, developing it, spending money on it, and then applying for patent and obtaining the patent. The inventor spent $100,000, 1 lakh rupees, and he was thinking the value of this patent is $1 million, but actually the value turned out to be zero after spending exactly $100,000, 1 lakh dollars, right? So this is the whole deal about valuation of patents, right? I hope this is completely clear to everybody. And now we'll go to our case studies and look at really what happens in the world out there. What happens with inventors, what inventions they create, what happens to those inventions when they approach companies to commercialize it, license it, or buy that technology. What do the companies do, and what kind of situations do inventors have to face and patentees have to face, and what are the important business, technical, legal considerations when you're looking at commercializing patents. Let's look at the next case study. Okay, this case study I'm talking about is an actual case study of something which actually happened, whereby there was a company or a startup called Eolas, which actually was awarded by a court, okay, $521 million in a patent infringement case. And the infringer was, guess who? The big well-known multinational company called Microsoft Corporation. Okay, Eolas had a patented technology, or in fact multiple patents, which were being used by Microsoft without license. And what happened was, the court awarded $521 million to Eolas for infringement of patent. Okay, so let's look at this case study. Let me give you a background of this. What are the issues that come up? To give a background to this case study, what are the issues that we have to keep in mind and which we will be dealing with, we are looking at through this case study and example. Okay, the background of this case and how we look at this case is, the question of application of software in the real world. We may create that program, this program, we'll write this software, we'll launch it, but where is it applied? Are people really interested in using it? What innovative feature have you added? How much of a difference does it make to people, or are there alternatives? These are the factors that are involved. Commercial exploitation of whatever invention you create, that is very important. How do you go about doing it? What kind of strategy do you have? How do you value it? How do you approach people? Are they listening to you? Are they willing to license or buy your technology? Very important. Large amounts can be awarded when you file cases against infringers. This is one of the things that comes out. This is the background. Okay, and the largest amount that was awarded at that time, this was I think in the early 2000s, largest amount awarded at that time was $251 million in the Microsoft EOLAS case, where EOLAS filed a case against Microsoft for infringement of its patents. Okay, so now let's get into the details and specifics of this case and see what it teaches us about commercialization and inventions and patents and inventors and users and companies, etc. Okay, so let's look at the facts of the case. EOLA's US patent number 5838906. This was one of the main patents. There was at least one other important patent related to the same technology. Now, EOLA's is a startup company connected with the University of California. Okay, they were owners, or they had got the exclusive rights for this patent 906 and one more patent. And what was the title of this patent 906? The title of this patent, which indicates what the technology which was invented, for which the patent was filed, was distributed hypermedia method for automatically invoking external application, providing interaction and display of embedded objects within a hypermedia document. Okay, I think most of you would not have understood what this means, but I'll explain that, don't worry. Okay, now let's look at the inventor of this technology. Was one Dr. Michael Doyle. Okay, and his other team members. There was more than one inventor. Okay, now Michael Doyle was a student at the University of California when he and his team came up with these inventions, and the University of California filed the patent, being the assignee or the applicant or owner of the patent. Ownership right was with University of California. Inventors were Michael Doyle, who was a student there, along with other people. And Michael Doyle himself set up this startup company called EOLAS to commercialize, market this technology, as well as to create and market other technologies also. Okay, so University of California gave exclusive rights for this technology to EOLAS to commercialize it, generate some revenue, and whatever revenues EOLAS manages to generate from giving license or enforcing the patent or anything like that, whatever revenues EOLAS generate, they were expected to share a certain percentage of that with the University of California. Okay, because after all, the University of California is the owner of the patent, so they must also get some share in the profits. Okay, so that was the arrangement. Now, this patent application was filed in 1994. The invention was created in 1994 or before that. These technologies were created before that, and the patent applications were filed in 1994 by the University of California, who were the assignee and owner of the patents. EOLAS, after filing their patent, now EOLAS people fortunately knew that if you want to disclose this technology or approach somebody, first thing we must do for any innovative technology which we want to protect is we must first file a patent application. Only then we should go and disclose or use in public or approach somebody for selling it. Otherwise, if we don't file a patent and we go and approach people, tell them this is they will go and file a patent and they'll steal the technology from us, and we will not even have patent or IP rights on that. So they were careful. First, they filed a patent. Then they started approaching these big companies which could use this software technology. Okay, and we'll look at what exactly this technology was. Okay, so they approached Microsoft in 1994. Okay, and guess what Microsoft said to EOLAS? Wow, very good, nice, but right now it doesn't fit with whatever we are doing, and we would decline the opportunity to take a license on this technology. So they basically, very polite way of saying, okay, we don't want to license your technology. Who are you? We are a big shot. You are who you are. We don't need to license. This is not invented by us. We're not interested. if at all we want to use it, we'll see about it later. Okay, this is what they said. They didn't license the technology, even though EOLAS had approached them after filing the patents. Okay, in 1998, the patent was actually granted by the United States Patent and Trademark Office. They got a patent certificate granted. Okay, now what does grant mean? Grant means that property has been given to you officially by the government patent office. Now you can enforce your rights on that. Now you got the final title deed to that property. The patent certificate is with you. Using that patent certificate, if you see that somebody is using that technology, you can go and tell them, you know what, we have created this invention, we have filed and obtained this patent. You are infringing our patent because in your software products you have incorporated this process, this my software process, which I have patented already, right? So you are infringing, you better stop this, and let's work out some agreement, some deal between us, based on which we may agree to you condone your infringement till now and allow you to use it in future, uh, subject to the condition that we get something in return. So that's what generally people do once they get a patent granted. And one thing you can see, patent application was filed in 94, it was granted in 98. 4 years it required to examine and process the application at the US Patent Office. Okay, right? So 1998 patent was granted, and then EOLAS filed a case against Microsoft in 1999, because now they have the property title, the patent certificate in their hand. It's officially their property, that invention, and Microsoft is using it in their products. Okay, and in 2003 there was a verdict by the jury in this case, awarding damages of 521 million to EOLAS, which Microsoft had to pay EOLAS. Okay, just imagine the amount, $521 million. Okay, huge, biggest, one of the biggest things that had happened till then. So subsequent there might have been others, but till then it was the biggest. And imagine the problem for Microsoft. We'll look at that now. Okay, now just to get a sense of what is this about, why such a big damage, $521 million, let's look at what this technology is. Okay, let's read the title again, and we'll go to the next slide where I'll explain to you what this actual process software methodology is, which was patented and which was infringed by Microsoft. Okay, so again we'll read the title. Distributed hypermedia method means web pages, websites, something related to internet and websites and information on websites. Distributed hypermedia method for automatically invoking external application providing interaction and display of embedded objects within a hypermedia document. HTML page is a hypermedia document. Okay, just to give you a sense of things, people who are aware of the IT or software side of it. Okay, now let's go to the next slide and understand what is this software invention which was created by Michael Doyle and his team, and which was assigned to the University of California, and which was being commercialized by this company called EOLAS. Okay, what was the software invention? What was the feature? The invention enables users, means users of internet and the world wide web pages. Invention enables users to automatically access and interactively use applications which are located on other computers over the internet. Okay, when you go to a web page, you're not just on that page. That page might have other embedded applications on that which are automatically accessible to you, and those applications themselves are getting information or data, and are live and interactive with information, etc., which are not on that same computer but on some other computer somewhere, right? What is the difference compared to the existing web pages? The difference was that till then the web pages were very static. There was some picture, there was some text, you could just go and look at that and do nothing with it. Just look at that and then go away. That was the kind of internet and world wide web and web pages that we had in the beginning. Okay, there was some page which had some pictures, there were some text, and maybe there was some table somebody had put. You could see that and then go to the next page or go to some other website. Nothing interactively you could do, like playing a video, accessing some images on somebody else's computer somewhere, activating some news feed, okay, or getting updates on the share prices, second to second or minute to minute, okay, uh, giving you other options for accessing some other information or product or data, or you get alerts from somewhere, this is happening, that is happening. Nothing. Earlier web pages, just static information, textual matter, pictures, just see, do nothing, no live anything, no interactivity, nothing, plain and simple. That was what web pages were like before this invention. This invention allowed users to automatically, without they doing anything, they don't have to click, they don't have to start some new app, nothing, automatically access and interactively use applications which are located on other computers over the internet. Okay, through this web page they could access automatically applications, data, computers over the internet and get the benefit. Means this was an interactive web page. Automatically interactive web page is what the invention was, compared to the static web pages which were available till then. Okay, what was the advantages of this invention? We saw what is the feature, how is different from existing page, what is the advantage. Users can access data, applications and superior processing power of other computers. Your computer may not have very good processing power, so some calculations, certain things you want to do or games you want to play, maybe you can't play with the limited processing power of your computer. But over the internet, using this automatically interactive web pages, you can access the superior processing power of other computers, maybe located in a different country. You can access data automatically and interactively which is located on some computer across the world from your web page. Okay, you could access other applications or programs which are located on other computers. Okay, this was the advantage of this technology. Okay, now many of you who are familiar with IT and computers and software will say, what is so inventive about this? Yeah, this so we use every day. Yeah, this is very common technology. So to that, what I will say is, you know what? About 25, 30 years later, to us now today, this looks like very common technology. Okay, but think of the early 1990s when this invention was created and the patent was filed in 1994. When the patent was filed in 1994, this is 26 years or 27 years back. The internet, mobile phones, interactivity, all this, seeing videos in one window, getting a feed on some latest news in another window of the same screen, all this was never happening. You could just see text, maybe photographs, that's it. Once you finish seeing, go to the next page or to the next website, that's all you had. Very static, colorless, very plain, non-interactive web pages were what you had. This technology enabled all that interactive that came subsequently, all these things happening. So we are not talking about the state of the technology today. What we are talking is 27 years back what the technology was and what improvement came through this software invention, right? Remember that. Don't apply today's standards and today's technology when you evaluate, okay, ye to, what is this? Yeah, this invention is not even, doesn't even look inventive. This is very common. This is common today. 27 years back it was not there. Okay, at least that's what the inventor and patentee said. I hope everybody is clear about what this invention is. Okay, now let's look at what happened now. Eolas has filed a case against Microsoft. In 1998, the patent was granted to University of California. In 1999, on behalf of University of California, Eolas filed a case against Microsoft. Now, what happened next? Let's see what happened next in this story. Okay, when Eolas filed this case against Microsoft, what were the implications for Microsoft? They filed a case in 1999. 2003, there was a decision whereby the court, the jury awarded $521 million to Eolas, which Microsoft was required to pay for the past infringement. On top of this, Microsoft would have been required to stop using this technology immediately, withdraw their millions of software programs across the world, and remove this technology from all their software like Internet Explorer and other technologies where these kind of interactive web pages were being used. They would have to withdraw. Apart from paying damages for past use, they have to withdraw this, and then if they want to continue using in future, they have to get a license and permission from EOLAS again. So big problem. There was implications were financial for Microsoft. $521 million was the financial implication. Then there were other implications, which is disruption of Microsoft's operations, because Microsoft was using this in many products. For example, one of the products was Internet Explorer, and their other products which were on the internet and which were being accessed or used through the internet were also using these technologies. Okay, so implications are both financial as well as a disruption of their business operations itself. Company will have to withdraw all these things, keep track of this, keep account, stop using, and then their systems don't work well, they have to withdraw it. Customers, millions of customers across the world are unhappy and very upset with Microsoft. That is disruption of operations. These were the implications for Microsoft. Okay, then let's see what happens next. What are the implications for the industry? It's not just Microsoft was affected. Microsoft was not the only company which was using this patented technology and infringing that technology without license. There were other many companies, big and small, which were using it in the industry, because everybody wanted to make their web pages interactive rather than be very plain and static. Everybody wanted an interactive web page, right? So what happened? It caused disruption not just for Microsoft, but across the industry in many companies. This technology was widely used and caused upset and disruption. Strange bedfellows. What that means? See, normally you would have seen, small developers, small programmers, they are against these big companies, especially Microsoft, because Microsoft and such big companies, they very often follow monopolistic practices, and they try to suppress small developers or have them sign up with them and work under their terms and conditions. So normally small developers and Microsoft are fighting with each other, they are against each other. But this is a case where small developers also are affected by this patent, Microsoft also affected by this patent. So both of them were united in opposing this patent or being affected by this patent. What is W3C? W3C is concerned disruptive impact on standard. W3C is an organization, internet related, which defines the standard for the internet, web pages, etc. And this technology by 2003, remember the invention was done in the 1990s. 2003 means almost 10 years have passed since the technology was applied for patent, was developed and applied for patent. In that 9 or 10 years time, everybody was using this technology, and it had to become de facto standard in the industry, defined by the W3 World Wide Web consortium also had defined this as a standard. It was disrupting something called a standard also. So disruption implications for Microsoft, disruption implications for the industry, disruption implication for the standards and standards body related to the internet and websites. You can just see the impact of this patent and patent related decision and this technology, and how it's affecting businesses in the real world out there. Big implications. Some questions which arose were, what is the future of the internet? The future of the internet is at itself at stake, because anybody and everybody is using this technology without license. Now everybody is required to shut down, stop. That means the internet literally will stop working. Who wants the plain or text and image one static page? Everybody is so used to this technology last 9 years, now they can't stop. It will literally shut down the internet. That was the question and worry that people had. Okay, some people blamed EOLAS. They are doing intellectual extortion. They are trying to protect some idea should be free, knowledge should be free, concepts, technologies, methods should be free. Why is EOLAS trying to enforce the patent, and they are trying to extort money from big and small companies? It's intellectual extortion. Patent should not be granted, patent should not be enforceable. This is what some people started talking. Okay, another question that arose was why Microsoft didn't deal with EOLAS. If you remember, the patent was filed in 1994, and EOLAS approached Microsoft to take a license in 1994 itself, but they did not. Okay, patent was granted in 1998, and in 1999 EOLAS filed a case against Microsoft. From 1999 to 2003, when this verdict came out, this decision with the 521 million damages came out, Microsoft still didn't do any deal with EOLAS for 4 years. After the case was also filed, patent is granted, case is filed, still Microsoft was reluctant to have a deal with a small inventor. They didn't want to. They said, why should we? We are big. We can use our muscle power to deal with this thing. We don't have to sign any deal, pay them any royalty fee. They are in fact willing to spend money on lawyers but not pay license fee to inventors and patentees. Okay. It's not just Microsoft. Many big companies are like this, not just in software industry, but other industries also. Why did Microsoft not make minor changes to avoid the patent? Okay, Microsoft could have made some changes on their Internet Explorer and other software which uses this technology to avoid the patent, but they were so overconfident that either these people will not be able to enforce, or the patent will not be granted, or it will not be upheld, or they may no damages will be awarded, or they'll lose the case. They were so overconfident of that they didn't even make, from 94 to 99, and even after case was filed in 99 till 2003, they didn't make any changes in their software to avoid patent. This was their level of overconfidence and arrogance, that we know this case is there, everything patent, but we don't care. Okay, nothing, who, what are they going to do? That was the attitude. Okay, and then we'll look at what happened next. Microsoft made plans to change Internet Explorer, the dialog box. Okay, so they, because now the decision has come against them and they are facing this financial liability as well as massive disruption of their company's business operations, they've now made plans to actually change Internet Explorer and similar software by not making it automatically interactive but introducing a dialog box, which if you introduce and it's not automatic, then it no longer infringes that patent, because in that patent it says automatically invoking that interactive program or application. Now what they said is, we'll put a dialog box where it will ask for permission, and then we'll avoid that patent. This, they made plans for that. They didn't actually change Internet Explorer, because changing Internet Explorer on a worldwide scale is no joke. Okay, it's a very serious matter, but they at least now started to make plans. Oh, if we have to change, how do we do it, what we'll have to do, and how will we redistribute and update all our software across the world. Okay, they started making plans for that. They also filed appeals against the verdict. Okay, now the damage amount on appeal, uh, 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 so what happened when they filed an appeal, the implementation of verdict was put on hold by the court, that Microsoft doesn't have to pay the damages right now and stop their use right now. They get time, because the Microsoft, the company, the party which is affected by the decision, is going to appeal against the verdict in the higher court. So that process itself takes months and years. So for that, during that period, the verdict, implementation of the verdict was put on hold. Means Microsoft was not required to pay the $521 million right there. It was put on hold for time, few months or years, till the matter was finally decided in the higher court. Okay, and the damage amount at the end of the appeals was revised to $565 million, more than what it originally was. But the verdict was put on hold. Okay, the organization, standards body, World Wide Web Consortium, they put in a request for re-examination of the patent with the US Patent Office in October 2003. They wanted the patent office to look at previously unreviewed prior art posted on public mailing list, which the patent examiner had not seen when he examined the application. He or she examined the application. So W3C was also concerned, okay, we want to get this patent invalidated, because it's not just big companies, but everybody is getting affected by this patent. So they initiated those proceedings in the patent office in the US. Okay, then what happens next? The USPTO invalidated the patent in March 2004. This was an interim order invalidating the patent. They said, we will continue doing a more detailed review process to continue. That's what they said. So now the patent validity itself was in doubt. There was an interim order saying it's invalid, but we are going to review in detail. This was the order in March 2004. So this again put a big question mark and uncertainty into the whole thing. Claimed, the question that arose was, were the claimed features, what the patent is granted for, whatever features the patent has been granted for, was it already known before 1994 when the patent application was filed? Before the patent application was filed, was this already known? That was the question which had to be got into and examined by the court in detail, or the patent office in detail. The question is, what is going to happen next? Let us see what's going to happen. Okay? There were more twists in the tail. In March 2005, the CAFC, which is the Court of Appeals for the Federal Circuit, which is a sort of a federal centralized court in the US related to appeals in various matters, including patent matters, CAFC sends the case back to the district court for reconsideration. Okay, it was Microsoft had filed an appeal with the CAFC. They sent the case back to district court for reconsider the case. Okay, whatever has happened till now, the case verdict which is there, reconsider it, district court. Okay. In the meanwhile, in September 2005, the PTO, after doing the detailed process of re-examination, again upheld the validity of patent, which in the meanwhile, in 2004, they had temporarily, sort of given an interim order saying it's invalid. Now again, they changed their mind and their position, and they upheld the validity of the patent. Okay, can you see the twists and turns, the ups and downs? One day, good news for EOLAS, another day, little sort of good news, at least partial good news for Microsoft. Then again, next year, something else happens. This is what happens in real life when you're dealing with patents, commercialization, value, infringement, inventors, patentees, and companies which are using and infringing these patents. Okay? In November and December of 2005, Microsoft notified its partners of changes in Internet Explorer. We saw that in 2003, they started making plans for changing Internet Explorer. Actually, they got to around to doing that seriously only 2 years later, more than 2 years later. It notified its partners of changes in Internet Explorer. We are doing these changes and we are going to issue the updated version of our software and all that. The question that arose at that time, why the delay in making this change? From 1994 to 1999, they delayed. From 1999 to the verdict in 2003, they delayed. From 2003 to 2005, again they delayed in making this change, which they could have done. Minor change it was, they could have done. Only the distribution is a challenge, but some point of time they would have to consider doing that. Issue the updated version of the software, which anyway they periodically keep on updating the software anyway, right? So the question is, why this delay in making this change? What was their overconfidence or their mentality or attitude which had them delay so much? The case still in court as of this. The questions that are there are, new prior art have to be considered because there are various parties which are affected. They are searching for and bringing new prior art of documents before 1994 which already disclosed this technology, and therefore they want to try and invalidate the patent. So now again the question stands, what will happen next? Let's see on the next slide what happens next. This slide relates to settlement by Microsoft and commercialization of this patent. In August 2007, Microsoft settled the patent suit with EOLAS out of court. Okay. After all these long dragging out reluctance, Microsoft didn't want to pay license fee, nothing. They were willing to fight the case in the US Patent Office, in the courts in America. Finally, in 2007, Microsoft settled the patent suit, the patent case, the dispute with EOLAS out of court. Because given the up and down, sometimes patent is held valid by the court or patent office, sometimes it's invalid, then again it becomes a lot of uncertainty and the matter is dragging, it's draining Microsoft energies and time, right? So they finally said, better we settle this matter out of court with EOLAS, close the chapter. Okay. So what was the settlement, the details of it never came out in public. Okay, it was all kept private as to what amount of money or what were the terms and conditions between Microsoft and EOLAS. Okay, but later on it came out that the share of the whatever money was paid by Microsoft to EOLAS, a share of that went to University of California. So just University of California share of the final settlement was $30 million. So maybe total amount Microsoft paid was probably significantly higher. Maybe it was $60 million or $100 million. We don't really know. But whichever way, that amount was significantly less than the damages awarded, which was $521 million earlier. Because in such a case, when you settle out of court, both parties have to compromise. Even EOLAS and University of California should be willing to come to an in-between solution. Even Microsoft has to come down to somewhere in between solution and agree for a settlement. Okay, but either case, if the matter is settled, both the parties gain, and the users and of Microsoft, they will gain out of this. That's why they settled this whole matter. Okay. After this big case with Microsoft was settled, then EOLAS was now very confident. So they started filing cases against other companies, and by 2009, they had sued a number of other companies for this infringement of this same technology and same patents, right? Because now they have a big outcome in the case with this huge multinational called Microsoft. They sort of won and settled and got money from Microsoft. Now they can approach other parties who will now be more carefully listening to what EULA says, right? And they sued them. And effectively, in 2 years' time, by June 2011, many companies, including big and small, had signed licensing deals with EOLAS, including Texas Instruments, Oracle, JP Morgan Chase, etc. You can see these are big companies, and these were not the only ones. Okay, so can you see by now, 2011, how many hundreds of millions of dollars EOLAS would have collected from Microsoft and many, many other companies, including some very big companies, right? Hundreds of millions of dollars they have collected already in settlements and licensing fees. Okay, it's not just 30 million, which was University of California share of the Microsoft settlement. Okay, so ULAS collected much more, probably running into hundreds of millions by June 2011. Let's see what happened next. Finally, let's conclude this by looking at what happened to the patents. Okay, the patents which were being challenged, sometimes it was being held as valid, then invalid, then again valid. In February 2012, an 8-person jury in the Eastern District of Texas invalidated some of the claims in the 906 and a related 985 patents. Okay, so claims are the sections which claim specific feature of the invention. Some of those claims were invalidated, and in July 2012, Judge Leonard Davis ruled against EOLAS and invalidated their patents. Okay, in July 2012, means now that patent no longer stands. It has been invalidated finally in the higher court, and EOLAS doesn't have a valid patent on that anymore. And 1 year later, so EOLAS appealed this also again to the CAFC, Court of Appeals for the Federal Circuit, CAFC. Okay, they again appealed to the CAFC, but again CAFC sustained that ruling of July 2012, which ruled against EOLAS and invalidated the patent. Okay, so finally, now EOLAS's patents have been invalidated. They say it is finally held that the patent is not valid anymore. Okay, it should not have been granted, or some ground it should not have been granted, and there was no infringement finally by all these parties. Okay, right? Now what happens? What do you think happens? Right? Can you think? Now, does EOLAS have to pay back all the money which it has collected over the years? Hundreds of millions of dollars EOLAS has already collected from Microsoft, Texas Instrument, and many other companies over the years. Initially, they found it tough, but later on, once the verdict came, etc., they started collecting these monies, and they have by now collected hundreds of. Do they have to repay that to whoever they collected from? Because now the patent itself is invalid. They have lost the case, right? No, they don't have to, as long as EOLAS's lawyers were smart when they signed the agreement with Microsoft, with Texas Instrument. And usually, if the lawyers are smart, they'll put a clause there. With this agreement, this matter is settled. The payment, once it's made, is non-refundable, irrespective of whether in future the patent gets invalidated. If EOLAS's lawyers were smart, they would have put such clauses. Even if this patent gets invalidated in future or anything happened, this money is unrefundable, non-refundable, whatever happens. Only under such condition we'll try sign a deal. Otherwise, we don't sign a deal. And Microsoft and other parties would have had to agree to such terms and conditions, because some years before they didn't know that in 2012 this is going to be invalidated. They didn't know. It could be invalidated or it might be upheld. If it gets upheld, if we don't sign a deal now, we'll be in trouble. So they signed the deal probably, and I'm assuming the lawyers of EOLAS had put such clauses there. Even if patent is invalidated in future, the amount is unrefundable. Okay, so my guess is EOLAS didn't have to pay money, because I'm assuming when such huge millions of dollars are amounts are involved, EOLAS would have been smart enough to hire smart lawyers who would have put such basic clauses in the agreement, the deals that are signed with all these parties. So that is what happened. Okay. Now, what do we learn from this entire exercise? Very often people have loose impressions about prior art. What technology is already in existence? People don't do a thorough search. They think I've created some new technology. I've seen nothing like this. It's not there in Tamil Nadu. It's not there in India. So they assume that nobody in the world has publicly used or disclosed. This is a big mistake. You have to do a very thorough search to find out about prior art. Don't have loose impressions. Okay. Very often technologists, they may create great technologies, but they underestimate what patents can do or how much valuable patents can be. They may very often, for smaller inventions, they may not even evaluate to file a patent application. They just let it be, oh, we do this kind of work every day. What is the question of patent? Some technology don't even know, okay, there is something called a patent right you can get on a new technology. Nobody has had awareness programs on patents and IPR for those technologies. So they don't know what is a patent also. There are things, sometimes this also happens, even though it's a little difficult to believe. Okay. This also, what we learn is difficulty of patenting venture. It's not easy. Firstly, to create the invention is difficult. Secondly, to obtain a patent is very difficult. It's time consuming, costs money. And then to commercialize the patent is even more difficult. Okay, very rarely commercialization happens. It is resources intensive. Time, resources not mean not just money. It is time, effort, and money. It is resources intensive. It is time consuming. It is uncertain and risky whether you'll get a patent or not, whether there'll be a demand for your invention in the market or not, whether you'll license or sell and get some money or not. Everything is uncertain and risky. You can get bogged down in litigation. Litigation can go on for years, and there is no finality or guarantee to a patent. Even if it is granted by the patent office, there's no finality or guarantee that the patent will stand after 5 years. Somebody may challenge it, and the patent can be invalidated after 2 years, 5 years, 8 years also. Right? Remember that there's no finality to a patent. And what do we learn? Continued. But in spite of the difficulties, small companies can enforce their patents against giants and make a lot of money out of it. All software patents were not invalidated, even though finally this software patent was invalidated in 2013. All software patents are not invalidated. Software, you can get patents on technological software inventions in India and in the US and many other countries of the world. And future, you can expect more software patent cases happening. So after 2007, 2003, 2007, etc., there have been many more cases, and even in future, you'll continue seeing more software patent related cases being filed and processed, and damages being awarded or settlements being made, etc. Okay. Important thing to understand is just creating a technology and patenting it is not enough. Commercialization is actually very difficult, and it's a big challenge. Okay, this is the one final big lesson we learned from this particular example. Okay, so with this we come to the end of this session for today. And if you have any questions, you can ask those questions, or you can send it through chat box, and maybe the program coordinator can ask those questions for this.
Thank you, sir.
And I'm a
Sir,
little sorry for the little overstepping of the time.
sir, can I ask the question from
Yes, sir.
participants?
Yes, sir.
Sir, one question from participant. In this win and win situations between the person who gets patent of his invention and the business who use that patent, what could be the social responsibility of the two towards consumers?
Okay. So win and win situation between whom?
Win and win situation between the person who gets patent of his invention and the business.
To whom they are licensing it? To
Sir,
whom they are licensing the patent, is it?
Yes, sir. Yes, sir.
Okay. And what is the question?
Sir, once again, I read the question. In this win and win situation between the person who gets patent of his invention and the business who use that patent, what could be the social responsibility of these two towards the consumer?
Okay, right. So who uses the patent will be, suppose it's a product like, for example, an improved motor for a washing machine. So the end users of that new technology are the people who are using the washing machine to wash their clothes. Their electricity bill will be less because the new motor, improved technology, patented technology, consumes less power. Okay, so the benefits are the users, and they have paid money to buy that washing machine, so they are the users and the people benefiting. And we see a real benefit: less power is consumed, energy is saved, electricity is saved, and money is saved for the users of the washing machine. Okay, and what is the social responsibility of the inventor or patentee, as well as the company or business which has licensed this technology and is offering this technology to the users out there? So my answer to that is, what is the social responsibility of a company like Reliance or Tata or Birlas or Microsoft or Infosys? What is their social responsibility? In this case also, these parties also have same social responsibility. Okay, there's no difference. Just because they have a patent, there's no other social responsibility. By the way, patents are for technologies which can be utilized on a commercial basis. They improve some technology, and because people are getting improved products, they are expected, or people who can will charge a little more money for that. That is what is happening. It's purely a commercial and business transaction. Okay, inventions or innovations which are in the nature of social innovations, okay, they are not allowed to be patented only. So neither the patentee will get the patent, nor there will be a business using the patent. So then there is no problem only, because social innovations are not protected through patents. So there's no problem arising due to such things. These are for like technological innovations where people get a definite benefit, and out of, if they get a 10x benefit, then they'll maybe pay extra money of 1x. They get benefit 10x, they pay 1x extra money for getting that technological benefit. Okay, so this is the social responsibility of the patentee and the company which is licensing and providing this technology to others. It's like any other company which is in business. What is their say social responsibility? Same social responsibility these parties also have to face. Now if somebody says these big companies, they don't fulfill their social responsibilities, that's not the problem of the patent system. Okay, that's the government has to look into that. Why are these large companies not fulfilling their social responsibilities? That's the government's outlook on that.
That's all
Yes,
the
next
questions,
question.
sir.
Yeah, any other
Thank you.
question?
No, sir, only one question from the participant. Thank you,
Okay,
sir.
sir. Right. Shall we conclude, sir?
Yes, sir. Thank you so much, sir, for your wonderful
Okay.
and informative presentation. Thank you, sir.
Okay, okay. This is Dr. Joe Patrick, right? Am I
No,
speaking
sir,
to
I am Robinson, sir.
Mr. Robinson? Okay,
Yes, sir.
okay.
Yes, sir.
Right. So, if I may, I would like to thank Dr. Joe Patrick, you, Mr. Robinson, the technical support people, the
Yes, sir.
principal management, and the entire college, Francis Xavier Engineering College, for inviting me, giving me this opportunity, and providing the support for this session. So, thank you very much. In case of any queries, you can send it later on also. It can be forwarded to me from the participants. Thank you very much to the participants for their time, attention, and participation. Okay. Yeah.
Okay, thank you, sir.
Okay. Thank you, sir. We'll conclude this session.
Thank you, sir.
Thank you.
Thank you so much, sir, for spending your valuable time to enrich our knowledge. Here I express my sincere gratitude on behalf of Francis Xavier Engineering College. Thank you so much, sir. Now I request Dr. Joe Patrick, Professor, Department of Mechanical Engineering, propose the vote of thanks.
Hello everyone, this is Dr. Joe Patrick Nandra, Professor, Department of Mechanical Engineering, Francis Xavier Engineering College, Tirunelveli, Tamil Nadu. My sincere thanks to Mr. Parve Kutrali, Principal, Associate, Karna and Karna Advocates and IP attorneys for their wonderful session. You have organized your talk very well and guided us completely without any fallback. My sincere gratitude to you again, and I also request to continue inspiring and support us in the future as well. I would like to thank all the participants for their wonderful participation and excellent cooperation. I thank you all. On behalf of Patent Information Center, Francis Xavier Engineering College, the faculty and students, I extend my gratitude to the organizing team, training and skill development team, the college management, and everyone associated with us. Thank you all and meet you all in another section. Stay safe. Thank you.
Thank you so much, sir. E-certificate will be provided after filling the feedback form, which is at description box. I would like to leave the quote here. Don't limit yourself. Many people limit themselves to what they think they can do. You can go as far as your mind lets you. What you believe, remember you can achieve. Stay home and stay safe. Goodbye. Have a nice day. Thank you so much.